police did not observe any injuries on him. And as EMS and other police first responders attempted to perform CPR, they noticed a pink, frothy discharge coming from Sarah's mouth and nose, which only increased as the crew performed CPR.
That pink stuff, it's like you never really find out what it was. That's really creepy part of it.
Yeah, I would be curious if in the trial documents they talk more about what they think that was, or whether or not the jury was presented with that.
I'm sure the jury sent out a note if they didn't.
No, they had to have. They had to have.
Police arrive and find a woman next to a bath. She's not breathing and her heart is stopped, but she's still warm. They notice her hair is wet, but her body is not. They're unable to revive her, and later her husband is found guilty of murder. But it turns out the lead detective is a serial fabulist. Was the husband unconstitutionally convicted? This story from the Sixth Circuit, plus DEI lists in the Fifth Circuit, this week on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, May 29th, 2025. So I have that murder mystery in the Sixth Circuit coming your way in a little bit. First, we're going to hear about what's going on down in the Fifth Circuit, but I want to introduce who's going to be doing our Sixth Circuit case in a little bit, and that's Nick DeBenedetto from IJ. Nick, how you doing? Welcome back.
Hi, Anthony. Thanks for having me back. I'm doing very well.
Well, great. Well, we'll hear a little bit from Nick later, but first, Bob. Now, this is a case that in some ways is not, there's not a lot going on, some might say. I mean, I know that people are passionate about these issues, and no disrespect to the parties involved or the lawyers involved, but in some ways, this is a little bit of a case about nothing. It's about lists of what gender and race people have at broadcast studios, but it really reveals a lot about how the administrative state works and all the machinations that go on with it. So, Bob Belden, who knows his way around the Fifth Circuit. What is going on in this case, and what's Judge Elrod talking about?
Well, thanks for having me, Anthony. I'm happy to be here with you and Nick today. Agreed. My case is not doesn't have the same level of interesting facts as Nick's, but we'll get through it and get to the interesting stuff here. Mine is National Religious Broadcasters versus FCC, and I think folks are probably familiar with the FCC. It's the federal regulatory body that deals with radio and TV broadcasters. And what's going on in the case, as you point out, is at some point the FCC decided it would start to require broadcasters, both radio and TV, to submit annual forms, this annual form called Form 395B.
Nothing better than an annual form for the federal government to require you to file.
Right. And as far as annual forms go at the federal level, this is actually, it doesn't seem to be that onerous of a form. You can print it off and it's nine pages with, in paper, and it's like mostly instructions, like almost all federal forms are. And you fill out information on like basically 2 pages. The FCC started collecting this kind of demographic data from broadcasters in the 1970s. And over the course of about 2 decades, they were collecting it. And Congress said, we need to do a little bit more. There's not enough diversity in broadcasting. And in 1992, Congress adopted something called the Cable Act, which basically said you need to adopt broadcasters, you need to adopt equal employment opportunity programs, and we're going to have you continue collecting this data and making it available to the FCC so that we can assess basically whether you're making enough progress on hiring minorities and women into broadcasting roles. And about 6 years after that act went into effect, the D.C. Circuit enjoined the FCC from enforcing it. And for about the next, I don't know, 2.5 decades, the FCC did not actually collect Form 395B or anything like it.
And it seems like that case, or I mean, the Supreme Court never took that case. Maybe they never even, the Clinton administration never even tried to take it to the Supreme Court. It's just like everything's kind of been frozen in amber because of, other than these forms, because of that DC Circuit ruling.
Right, yeah. After the DC Circuit ruling, the FCC tried to fix the underlying issues with the equal employment opportunity programs, but the FCC left the kind of form collection, data collection piece, in abeyance, I guess, for about 2 decades. And, I'm curious, Anthony and Nick, what's the longest you have had a motion or a request for relief held pending by a court or a government body? I think I'm probably around like 1.5 years, maybe, and that seems very, very long to wait for a decision. I'm curious.
I think
about
that's
you guys.
more. I mean, I've waited over 1 year for an opinion.
Mm-hmm.
Nick? But
Well, I was not around in 1992, so listeners may be surprised to learn that in my young career so far, I have not had many motions pending that the court has held on to for a long time. But I will cheat a little bit and say that during a previous position at the Cato Institute, when I was working at the Center for Constitutional Studies, we filed an amicus brief, several amicus briefs actually, but one in particular at the Texas Supreme Court in a case called Borgelt, which took a very long time to reach a final decision. I think I had since left my position at Cato for over 1 year before the opinion actually came down.
Oh, man. Well, that is a long time, and I felt like waiting more than 1 year was a long time. But I raise this issue because while the FCC held this data collection, they paused it for about 2 decades. Under the Biden administration in 2021 or 2024, the FCC decided, hey, we're actually going to start collecting this data again, and we're going to have broadcasters submit this form again. And they made a couple changes to the form, but they did it in the context of ruling on a motion for reconsideration that had been pending since 2004. So at the point that the order at issue in this case actually comes out, some group of broadcasters somewhere has been waiting 20 years.
So
to
is
find
that a
out.
motion like in the rulemaking process, or like what quote unquote court was it even in?
So it was before the FCC. I think it was a part of, you have notice and comment rulemaking. I think it was a comment, and then FCC made sort of the final version of the regs available in 2004, and you can submit additional requests to change things. And because Form 395B, this data collection was just going to be paused, I guess the FCC just left the reconsideration request hanging out there and formally ruled on it when it entered the order at issue here.
I wonder how many, attorneys over the years filed that they had, left the firm, and the new attorney was now making an appearance, and that I probably no one did anything, but I wouldn't be surprised if the attorneys who originally filed that were long gone by the time the motion was ruled on.
They certainly hadn't thought about it in a while, I'm sure. The FCC enters this order in February 2024 and says, hey, this form is back on. You need to be submitting this data. They expanded the categories of jobs that were covered in the form and added a couple categories of demographic information that could be included on it. But a group of broadcasters sued basically immediately to enjoin its enforcement. And the FCC denied all requests to kind of avoid being subjected to it. And so the broadcasters, I said sued, you don't technically file anything in a district court or a complaint or anything. You petition directly to the Fifth Circuit for review of the agency order. And a group of broadcasters did that here. And there's an interesting point in the opinion, a couple pages, where the Fifth Circuit talks about associational standing. I don't know if either of you have strong viewpoints on that issue that you want to, get out right now. I understand from people who are more keyed into the issue that it might be on shaky foundation at present, but the Fifth Circuit.
Yeah, and it was perhaps going to be a thing in the birthright citizenship oral argument, and didn't really come up. Because I know some justices in the Supreme Court have been skeptical about it lately. Yeah. But yeah, it seems like Fifth Circuit, is just accepting that it's still a thing and moving on.
Yeah, not an issue, but the court stops on it for a couple pages and then moves into the merits. And there are basically two arguments that the FCC is making here. The first is, we're a federal agency, and like every other federal agency, we are authorized to do things in the public interest. And so what happens after that is the FCC is made to try to identify statutory hooks somewhere to hang their public interest objective and use that as sort of a basis to collect this data. And the court looks at a few of the options that the FCC offered and says, at the end of the day, for each of them, the FCC never really explains how collecting demographic data from every broadcaster in the country is connected to the FCC's core function of actually licensing those broadcasters, or making sure that, the introduction or the beginning of the opinion talks about life before the FCC and how it was total chaos trying to, you go onto the AM or FM spectrum and you're getting all these
questionable history, by the way, but we don't need to bring that up right now. I know Jesse Walker at Reason has written about that. But
And while reading this case, actually, I texted some friends of mine that I keep in close contact with from Cato and said, I want to hear the libertarian sort of counter history to the great and good government coming in to regulate the wild, wild west that was, the radio airwaves.
Yeah. What do you hear back, Nick?
They didn't provide me with anything interesting, so I guess it's going to be a homework assignment that I have to do.
Well, I've learned my lesson. Next time, I'll get to the bottom of it before I present the case, so we can talk about it. But at the end of the day, the FCC never really explains, we need this demographic data to help us do A, B, or C. That is our core function as this federal agency. So the court rejects the argument that collecting this data is just in the public interest. And the court takes a view of sort of agency power that is contrary to what many people are probably familiar with from the past few decades, and sort of is really focusing in hard on the statutory authorization from Congress and saying, public interest is not some freewheeling power that you can invoke as like a totem and just get away with, new programs, new burdens, that kind of a thing. And then the second basis that the FCC offered to justify collecting the data was that I mentioned the 1992 Cable Act. FCC says when Congress adopted that act, it said the FCC shall not revise the forms that were being collected to get this kind of data. And the court kind of walks through how that is true. That is what Congress said, but Congress was referring to basically there's a subset of 3 potentially relevant regulations. The court says Congress was referring only to 2 of those, and those 2 regulations had been overturned in the sort of 1998 case that led FCC to put the data collection on the back burner and just kind of sit around for 2 decades.
So it's like Congress was referring to something that now doesn't exist, is basically the argument.
Yeah, you can collect this data to help you with programs that currently exist, but 20 years hence, if those programs no longer exist, you can't collect data to promote them. And so that is kind of the end of that opinion. The Fifth Circuit sends the FCC back to the drawing board because they don't have statutory authority to force the collection of this data. And, the broadcasters had raised other probably more interesting free speech and I think property rights claims that the court just doesn't reach because there's no statutory authority. But that's my really interesting case. And now if you guys want to talk about a little habeas, I'm happy to do that.
Well, let's first get Nick's take on what's going on here in the Fifth Circuit. It does seem this is a hard opinion to read through, I think, because it really does depend on every jot and tittle in these statutes, and it's kind of it's not as close. It's a close examination that you don't often see in these kinds of cases, because usually they just say, well, there's authority here, and it's close enough, and the agency wins.
I agree. I was struck by that as I was reading the opinion, and I also couldn't help but read this opinion without putting my glasses of the Supreme Court's recent skepticism towards administrative power and administrative agencies. Although things like the major questions doctrine are not directly invoked in this case, it's hard for me to decouple the tight statutory analysis from sort of the vector that is moving through the law right now that seeks to limit agency power and restrain it basically to the four corners of whatever Congress authorized it to do in its statute. So did either of you see that as well? Do you think that there is kind of a broader sort of major questions flavor to this case, or is it just good old-fashioned statutory interpretation because this issue goes back to the 1990s?
Yeah, I mean, I wouldn't see it as major questions, other than just major question doctrine as part of this whole general ambiance
Right.
about being skeptical of regulatory authority. But it's definitely a kind of, you might say, a hard look at the authority that Congress has given the agency. I mean, I'm reminded of like this is a question in administrative agencies about whether they have authority that Congress has given them. There's a very parallel question in local government law where a state legislature has given a local government, usually a city or a county, but sometimes special governments, whether they have certain powers. And this almost reads like a case from like the 19th century where that was read a lot more closely. So there's a lot of cases that today we kind of read, IJ kind of read as like economic liberty cases or a property rights case, but they're not actually constitutional cases. They're cases about whether the city like has a power to, say, license peddlers. That was an issue that came up a lot. And they would very closely read the grant of authority to the city and say, look, you may have the authority to license this one thing, but you don't have the authority to license this, or this kind of tax and not this kind of tax. And then later, the deference got much, much greater. So just there's police powers, and police power is pretty broad, and so the city can do all this stuff. Kind of have a similar evolution in agency law, and this is a little bit of a step back. So I mean, I would love to see this kind of skepticism of agency power in a lot of areas. I gotta say, I am a little skeptical that this would happen in all kinds of other things that agencies do. I think the whole political explosiveness of the demographic data is definitely driving some of this. So we'll see. It is the Fifth Circuit, and maybe they're skeptical of a lot of agency stuff these days. So maybe that's what's going on. But I won't hold my breath in future cases on something that's much more mundane, perhaps. But maybe maybe it portends a trend in that direction.
Yeah, the vibes are definitely that administrative power is at its low point right now, at least in recent memory. And I think I like about the opinion that it doesn't tend to emphasize too much the nature of the additional information that the FCC was saying broadcasters had to collect. Anthony's right that the FCC added stuff like gender identity and a number of other things that I think, whatever side you're on, people feel strongly about them. But the opinion does a good job, I think, of saying here's a statutory provision and that doesn't link up to what you're trying to do. And I'd love to see more of that.
I thought maybe I would, before we close out on this, tee up one other question for you guys. In recounting the history of the statute, the panel talks about congressional findings that there was not enough women and minority individuals in management positions in the broadcast industry. And again, I don't want to take us too far afield, but this gave me a flashback to my federal courts class. And I think, if I remember correctly, we were discussing either Morrison or Lopez, the Commerce Clause cases. And my Fed courts professor got very exercised that the court went against congressional findings, saying that these, that the relevant laws in those cases went against or were necessary or relevant to the regulation of interstate commerce. So do we at IJ spend a lot of time thinking about congressional findings and the role that they should play in legal interpretation?
Yeah, I mean, definitely congressional findings or legislative findings, or often city council findings, which is, is all kind of the same idea that the legislature, whatever level of government, has come up with certain facts, and then it's justified its actions with those facts, which we do like, right? We like laws that have some facts behind them. But then the question is whether you're able to second guess those facts with your own facts in a lawsuit. And I know often when people are justifying laws, they're saying, well, once Congress or the legislature has put those facts forward, like you can't second guess them. And I think that was a big part of Morrison and Lopez and other cases in that area, where you already kind of have a rational basis standard under the Commerce Clause. And so, hey, what are you even trying to do if you have those facts in the record, so to speak?
Yeah, I don't have much to add to that. I think it pops up a lot in our zoning cases that you'll have like a local government official at a hearing saying, well, we all know that trash is a serious problem. And then it's like, it's a big issue if for the rest of time it's a legislative fact that trash is a serious problem. But, if we can go in and ask, where's all the trash, then, I think that's fine. But I don't have anything useful to add to Anthony's institutional knowledge about IJ.
Well, I think Bob has given us plenty of useful thoughts about this latest news from the Fifth Circuit. So we're now going to move to the Sixth Circuit. So this case is unpublished, which kind of is a head scratcher to me, because the court spent a lot of time on it, and it does seem useful in habeas law, although not useful from a defense attorney's point of view. But Nick, this is this is one of those cases where you read it and you're like, wow, if I was on the jury, I don't know where I'd come out with all this, but it sure is interesting.
It is very interesting, and as you teed it up very well, Anthony, this case is unpublished, but the underlying facts are the stuff of true crime podcasts. So I don't know if anyone in the short circuit listening audience has any crossover interest in those sorts of podcasts, but if you do, this is for you. So at root, this case is an appeal from the Southern District of Ohio after the district court denied a man named Ryan Widmer's habeas corpus petition. He was convicted back in 2011 after being tried 3 times of murdering his wife. The panel in this case was made up of Judges Moore, Clay, and Thapar, and Judge Clay wrote the unanimous opinion of the court. And I'll flag at the outset here for listeners that there is a lot going on in this case, and I commend it to you, but time probably is not going to permit us to cover every single issue. So I'm going to give you the facts that you need to tee you up to do a little bit of additional exploration, and we will cover sort of the flagship issue about our dishonest detective. So on the night of August 11th, 2008, dispatch in Hamilton Township, Ohio, received a 911 call reporting that a woman had drowned in her bathtub. The call was placed by her husband, Ryan Widmer, who said that he believed his wife, Sarah, had fallen asleep in the bathtub and was now dead. When the police arrived on scene, they observed Sarah lying naked on the floor of the Widmer's bedroom. She was unresponsive, was not breathing, but was still warm to the touch. Somewhat strangely, her hair was damp, but her body was dry. Mr. Widmer was present and dressed only in boxer shorts when emergency personnel arrived. The police did not observe any injuries on him, And as EMS and police first responders attempted to perform CPR, they noticed a pink, frothy discharge coming from Sarah's mouth and nose, which only increased as the crew performed CPR.
That pink stuff, it's like you never really find out what it was. That's really creepy part of it.
Yeah, I would be curious if in the trial documents they talk more about what they think that was, or whether or not the jury was presented with that.
I'm sure the jury sent out a note if they didn't.
No, they had to have. And so additionally, another strange wrinkle about the lead into this case is that police and EMS noticed that there were also no signs of obvious trauma on Sarah's body. The emergency responders continued to try to revive her as they were transporting her to the hospital, but they were ultimately unsuccessful, and she was pronounced dead approximately 30 minutes after arriving at the hospital. Now, while at the hospital, Widmer told the charting nurse that he had found Sarah in the bathtub, not breathing, but facing up. So now, the county coroner's office dispatches its investigator to respond to the emergency room. The coroner, like the police and EMS personnel, observed no obvious signs of trauma on Sarah, also noticed that her body was dry and that her hair was damp, and he also noticed that there was no pruning on her fingers, which would suggest that she spent a significant amount of time in water. Listeners can think about swimming in the pool at some point this summer when your tips of your fingers look wrinkly like raisins. So the investigator then spoke to Widmer, who reported that he was watching football downstairs when Sarah went upstairs to take a bath. Widmer said that he was afraid that Sarah would fall asleep in the tub, and that about an hour later, when he went upstairs, he found her unresponsive, face down in the water underneath the faucet. So now the main character, or perhaps the most important character in our story for today, Detective Jeff Braley, arrives on scene at the Widmer's home as Sarah is being transported to the hospital. He's there to process the scene and collect evidence, and so on a preliminary tour of the house, he notices a few things. First, he notices that the bathroom and floor were more dry than you would expect for, having someone just had taken a bath, being removed from the bathtub at some point. Things were oddly dry. The floor of the bathroom, likewise, was dry, and there were 2 pinkish red stains on the carpet. Braley obtained consent to search the home and packaged and processed some additional evidence, water samples, bath products, a used Lysol wipe, some towels from the bathroom, and a carpet sample from where Sarah had been laying in the bedroom when emergency responders first arrived on scene. The Miami Valley Crime Lab tested these samples, and in particular, they focused on some DNA that was recovered from underneath Sarah's fingernails, which the investigator from the coroner's office had taken effort to preserve by placing bags over her hands when he arrived at the hospital. And that DNA only revealed that of Sarah herself and an unknown female.
That's another real mystery.
Yeah. We never find out who she is, right?
We never find out who she is either. And
not her husband.
There was no DNA found traceable to him, according to the court, under her fingernails, which sort of undermines the theory that there was a struggle or some kind of she took some sort of defensive action to prevent herself from being drowned.
Right.
So the following day, the Warren County coroner, Dr. Russell Updegrove, performs an autopsy. And at this point, Detective Braley already considered Sarah's death suspicious, and Dr. Updegrove shared with him that he had a preliminary opinion that Sarah had drowned and that her cause of death was a homicide. Dr. Updegrove observed in particular that Sarah had external bruising on the face and neck, and that she also had deep muscle hemorrhaging in her neck and contusions to her scalp. And so at Widmer's third trial, Dr. Updegrove testified to his final conclusion that her death was a homicide. He based this conclusion largely due to the fact that Sarah, he believed, was dead when first responders began administering CPR on the scene, and therefore her injuries were not caused by resuscitation efforts. and another testifying pathologist who testified on behalf of the state agreed with his conclusions that Sarah's injuries were unexplained by CPR. And if it's useful to the audience, I can provide just a little bit of color here because I was an EMT prior to going to law school. This action, these
we have our
particular
expert.
well, it would have been beyond my scope of care to be able to try and intubate someone, at least in Pennsylvania. That did not fall to an EMT basic, but I was trained on a dummy on how to do this, and it is not easy to do. So one of the details I've omitted was that EMTs tried to intubate Sarah several times and were unsuccessful. And what this entails is if the listening audience thinks about like a tongue depressor that your doctor may use to examine the back of your throat, except it's metal and longer and curved. And so what emergency personnel will do is insert this into a patient's airway, depress the tongue, and at the same time try to lift the patient's kind of jaw to open up the airway, at which point they will insert a tube to assist the patient in breathing. This has been known to cause some injury. Usually it's your teeth that you're most concerned about as they're sort of cranking that depressor down. But, you know, as the defense's current or rival pathologist who also performed an autopsy surmised, some of Sarah's injuries could have been caused by the resuscitation efforts, including CPR, which can also lead to broken ribs and some other bruising and problems like that. The defense's pathologist, Dr. Spitz, said that he agreed that Sarah drowned, but would have, because of this possibility that the resuscitation efforts would have injured her, would have called the death undetermined rather than a homicide, the cause of death undetermined rather than a homicide. The defense also produced a second pathology expert, Dr. Michael Balco, at trial, who agreed with Dr. Spitz's findings and further presented the idea that Sarah may have died due to an underlying cardiac condition known as long QT syndrome, which has been associated with sudden drowning deaths. Friends of the Widmers testified that Sarah had a habit of falling asleep at odd times and places, that she had a history of persistent headaches, and Sarah's mother testified that Sarah had a heart murmur and a cleft palate as a small child, all of which are things that are associated with long QT syndrome.
You kind of wonder why she was taking a bath if she had that condition in the first place, by the way.
Yeah, I would imagine that it's, even though that condition is associated with, some drowning deaths, it's still probably very rare that the stars align in such a way that someone drowns. So on August 13th, 2008, this is 2 days after Sarah's death, Widmer was charged with aggravated murder and arrested. The police executed a search warrant on his home, which enabled Detective Braley to conduct a more thorough search than he had before. Most significantly for our purposes, he dusted the bathtub for fingerprints. And upon dusting for prints, he observed streak marks that he believed were made by human hands, but was not able to lift any prints that were fit for comparison from the tub. So subsequently, the Miami Crime Lab, the same one that analyzed the DNA underneath Sarah's fingernails, also dusted the tub for prints on 2 occasions using different methods, once at the scene and then once in the lab, but was also unable to recover any prints of comparison value. So now staying on the bathtub for a second, later on, 3 months later, the state had William Hillard, a senior criminalist with the city of Cincinnati, examine the tub. He did not apply any additional treatments to the tub, but testified from the existing fingerprint powder already applied that he was able to identify a forearm impression that he believed was made by an adult male, which he opined overlaid circular marks on the bathtub, which were likely left by bottles. He further indicated that there were white marks in the tub, which suggested that someone had attempted to clean it. What he couldn't say was when any of those impressions were made or when the tub was wiped.
Could he say what the bottles were? Like, were they shampoo bottles, or is the implication that they were like cleaning materials or something?
I don't recall off the top of my head if the panel describes exactly what he thought they were, but the inference is that they were likely cleaning, materials for the tub.
Yeah.
So
All
as I
this
mentioned,
seems like stuff that can happen every day, of course.
Yeah.
certainly,
You
yeah,
put your arm on a
There
tub.
are
or try to
forearms
clean
in a
it.
bathtub every time you get in.
Right.
yeah. And so, as I said before, Widmer was tried 3 times. The first trial occurred in July 2009, where he was convicted of murder, but he successfully moved for a new trial based on juror misconduct. The second trial happened in May 2010 and ended in a mistrial when the jury was unable to reach a verdict. And finally, the third trial occurred in January 2011, and he was subsequently convicted of murder in February 2011. So now, the plot thickens even more because prior to the third trial, the state developed a new witness whose name was Jennifer Crew. She claimed that in October 2009, Widmer confessed to Sarah's murder directly to her. Crew met Widmer when the two began regularly communicating via a website established to support Widmer's innocence. She claimed that they began communicating fairly regularly after first meeting each other through the website, and that he called her one day crying and confessing to the murder and saying that it happened during a physical altercation after Sarah confronted him about cheating on her, using pornography, drinking, and smoking. Widmer then allegedly claimed that he confronted Sarah in the bathroom and hit her, causing her to bang her head. Then he blacked out and came to at the side of the bathtub, and when he did, he saw that Sarah was not breathing, but her hair was wet. And so, according to Crew, he attempted to cover up the death, including by cleaning up the water. However, the defense produced rival testimony by another supporter of Widmer's who testified that she had a 2-hour phone conversation with him on the night of that alleged confession, which ended around 11 p.m., and that he did not seem emotionally distraught or upset after the call. So, now...
And that's not necessarily contradictory, because, right, he hung up, and then 6 minutes later he could have confessed. I mean...
That is true.
Weird things happen with murder suspects. I guess.
Or confessed and then 6 minutes later felt better. You know, I mean,
Absolutely. And I also had the thought that if Widmer is the type of person to have been able to murder his wife and convincingly clean up the evidence, the fact that he didn't sound distraught on the phone probably wouldn't be indicative of very much. So now, to save the listening audience a lot of procedural history, I will just tell you that Widmer pursued a variety of appeals and ended up losing all of them. So at this point, he is left with a habeas petition in the Western District of Ohio, and the Western District of Ohio rejects his petition but certifies that he may appeal certain of the claims raised in his petition. And for our purposes today, we are going to discuss sort of the main event. But before we get there, it's worth noting that the Sixth Circuit had a very deferential standard of review to apply in this case. And the standard of review is governed by the Effective Death Penalty Act of 1996. I'm sorry, the Anti-Terrorism and Effective Death Penalty Act of 1996 that I'm going to call ADEPA. And so ADEPA bars federal courts from granting habeas relief to a petitioner on a claim that was adjudicated on the merits in state court unless the decision was contrary to or involved an unreasonable application of clearly established federal law as determined by the Supreme Court, or was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. So basically, the court that adjudicated these claims on the merits had to have gotten the decision so egregiously wrong that there is no room for disagreement about the outcome. So this is a very, very, very deferential standard that federal courts are to apply to these cases.
I mean, I often say it's not exactly the same, but think qualified immunity. It's got to be really wrong in order to hit the standard.
And so I signposted for everyone before that Detective Braley is going to be a person of interest. He's the person of interest in this case. And so before the start of Widmer's second trial, his defense counsel obtained an employment application that Detective Braley submitted to the Hamilton Township Police Department in 1996. And based on some irregularities in the application, defense counsel suspected that Braley was lying about his application and began to subpoena records from his prior employers in an effort to verify the information he provided. The state and Braley unsurprisingly moved to squash the subpoenas, and at a hearing on the motion conducted on May 5th, 2010, Braley acknowledged that there was some inaccurate information in the employment application, including that he had a master's degree and that he had attended a college in Florida. Other information about his background was also revealed to be inaccurate or false. For example, he worked as a postal inspector for 2 years, when in fact he had only worked as a clerk at the post office for a few weeks. However, during the hearing, Braley maintained that he did not fabricate the application and in fact never wrote the application at all. He claimed that the application itself had been fabricated. Later in the same hearing...
How could you say... And you're saying I never applied for the job is basically what his excuse was.
Yeah, it certainly feels like one of those situations where the effort to deny is worse than the lie itself. And so later in that same hearing, he testified that not only did he never send in this application, but he never filled out any application. And so the Ohio trial court eventually concluded that despite this inconsistency, any probative value in introducing questions about the fabrications in the application would be outweighed by the undue prejudice and likely to mislead the jury, given that the application was remote in time to the events of the case and there were questions about its veracity, and granted the state's motion to quash the subpoena. So in other words, the trial court was concerned that this would lead the jury too far afield from the main issues in the case. So now, before Widmer's third trial in November 2010, the Ohio Bureau of Criminal Identification and Investigation issued a forensic analysis of the handwriting on the 1996 application and concluded that it belonged to Braley, contrary to his testimony in the hearing on the motion to quash. The Bureau did not find any evidence that the application had been subsequently altered after Braley allegedly completed it. And following the Bureau's report, Widmer moved for the right to cross-examine Braley about the dishonesty in the application at his third trial and to present as a defense that Braley's dishonesty may have impacted the investigation of Sarah's murder. The trial court again denied the motion, finding that the authenticity of the application was still contested, and the issue of whether Braley lied on the application was to be collateral to the issues in the trial. And the plot thickens yet again. After Widmer's conviction in February 2011, the Hamilton Township trustees hired an outside law firm to conduct an independent investigation of Braley based on the questions about his background that arose during the trial. And if memory serves, the opinion says that this action took place the day after the conviction was secured on Widmer, which is tough.
Convenient timing.
Yeah. So after the firm completes its investigation, it issues a written report to the trustees in June 2011. The report found that there was misinformation about Braley's background in the employment application alongside a resume letter that he sent to the chief of police. The report also concluded that both documents were authentic, but that they never led to his promotion or hiring. The report further detailed that Braley had falsely told numerous members of the Township Police Department that he was formerly a member of the Special Forces in the military, and specifically that he was a parajumper or pararescue jumper while in the Air Force. And so when interviewed by the firm during the investigation, Braley denied ever being in the Special Forces and denied ever telling anyone that he was in the Special Forces, although he did actually serve in the military. However, the report went on to explain that it was, quote, everyone's understanding that Braley's false Special Forces military background was the reason that he was put in charge of the township's Thor unit, which was a special operations unit established around 2002 or 2003 that conducted police raids, so like a tactical unit. Nevertheless, the report concluded that Braley's lies had, quote, no particular impact on the township, but the report did recommend that the trustees conduct a pre-disciplinary hearing regarding Braley's misconduct. So now, where the Sixth Circuit picks up, Widmer is raising related arguments about two U.S. Supreme Court cases, Nippoo versus Illinois, which is from 1959, and Brady versus Maryland, which is from 1963. And in Nippoo, the Supreme Court held that the Due Process Clause is violated when the state knowingly uses perjured testimony to obtain a conviction. And so to succeed on a Nippoo claim, a petitioner must show that first, there was a statement that was actually false, second, that the statement was material, and third, that the prosecution knew the statement was false. And for a statement to be material under Nippoo, it has to have the effect of basically influencing the jury in its ultimate conclusions about the guilt or innocence of the individual. So in companion to Nippoo, we have Brady, where the Supreme Court held that the suppression by the prosecution of evidence favorable to an accused violates due process, where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution, and both impeachment and exculpatory evidence are subject to Brady. And so to establish a Brady violation, a petitioner must demonstrate that first, the evidence is favorable to the accused, either because it is exculpatory or because it is impeaching, and second, that the evidence was suppressed by the state either willfully or inadvertently, and third, that the evidence was material.
And it's essentially all of this, I mean, absolute lies that this guy told. They had nothing to do, well, that we know about. They had nothing to do with this investigation, right?
And that is where the Sixth Circuit ultimately comes down. So again, the Sixth Circuit was required to determine whether or not the last court's conclusions, so in this case it was the Ohio Court of Appeals based on the procedural history of Widmer's criminal case, that rejected his claims both under Nippoo and under Brady. And the punchline is that materiality in this situation goes to innocence. So the fact that Braley's background and the fact that he lied about his background doesn't really impact the analysis of whether Widmer actually murdered Sarah. These are remote and what the court calls collateral to the issue that the jury was tasked with determining. And the Sixth Circuit goes on and says, even assuming that Braley lied, he still attended the police academy, he still became a detective, and received a promotion to lieutenant while he was employed by the Hamilton Township Police Department. And he had been a lieutenant for about 4 years prior to the Widmer investigation. And there was no reason to suspect that he testified dishonestly as to his experience or lack thereof as a detective as it relates to things like evidence collection or crime scene processing. And as kind of a final nail in the coffin, which is sufficient to dispatch the questions about materiality, the court notes that even if Braley's credibility was totally undermined, there were other important witnesses in the case who corroborated everything he said about the crime scene, including other police officers and EMS personnel and presumably the coroner as well. And so even if you couldn't trust Braley, there were still other people who backed up pretty much everything he said. And so because Widmer could not establish this materiality, the Sixth Circuit concludes that the Ohio Court of Appeals did not err and affirms the denial of his habeas petition.
Yeah, at the end of the day, didn't kind of matter. I mean, that's the court's opinion, but while there, we get this wild ride about this guy's background. Bob, were you convinced by how the court weighed these facts, or do you do you smell a rat there somewhere?
You know, I think that the lead investigator influences what happens in an investigation like this so much that if there were credible evidence that, you know, he applied or didn't apply or lied about that and then lied about his experience, in addition to having an absence of actual real experience, I think that that could have been material to a jury. But again, I think Nick pointed out the standard of review here. It is so far removed from whether, you know, you think the jury actually did the right thing. It's about whether the appellate court judges at the state level were so wrong about their review of what happened at the trial that we should overturn what they did. So I think they probably reached the right result under AEDPA and, you know, the habeas regime as it exists now. But I think if I were a jury in this, or a juror in this case, I would certainly want to know that Braley had these issues, and I think it would have influenced what I thought about the case.
Yeah, because I mean,
definitely.
It seems like the argument, the state's argument, is that sure, he was a serial fabulous to get this job, but there's after that, you know, he could have just been an honest person and done everything on the up and up. And
we promoted him to lieutenant. You know,
Yeah.
what more do you want? He got a promotion. He's an honest guy.
And I mean, if you know, we talk about character evidence, like character doesn't. Most people know that character can change, sure, but often it doesn't. And this is only 4 years later in this guy's
Right.
life. It's not like this was something in his youth, and you know, it's 40 years later.
Yeah.
So it does seem like if I was a juror, I wouldn't want to know this guy is a big time liar, but the fact that they had the evidence kind of didn't matter in the end anyway. I mean, you make a good point, Bob, that the detective can influence them, and maybe their memories were influenced by, you know, him influencing them. But such is the, you know, crime investigations.
Yeah.
And Anthony flagged at the beginning of the program that he thought it was interesting that this case was unpublished. And that got me thinking about, you know, why that might be. As I was reading the opinion, this was something that I was contemplating. And I think that the court may be reluctant to close the door on future, you know, dishonest investigators. And I was trying to put my shoes in the judge, my feet in the shoes of one of the judges, and think about, you know, what would be the future implications of this case if it were published. And both as a judge and maybe as a potential juror, I would think differently about a similar situation if you could establish a sort of continuous history of fabrications by the lead investigator. So, for example, if it also came out that Detective Braley had lied on police reports and had lied while working his job as a lieutenant detective in the Hamilton Township Police Department, then I think we inch closer and closer to materiality. And certainly as a juror, I would want to know that.
Yeah. Well, it is quite a story, and readers and viewers can make up, and listeners can make up their own minds. But until that time.
One word of caution to the listeners or viewers or readers. If you're arrested and incarcerated for a long time, do not be like Mr. Widmer. Don't make friends on the outside that you've talked to about your crimes, because one of them may be a person who shows up later and says, yeah, you know, Nick confessed to me. We talked on the phone all the time. Just don't do that. Don't do it.
It shows you just how amazing and contradictory and complicated people are that could happen, you know, whether he's guilty or not, that those exchanges took place. But
yeah,
we'll see. But for everyone else, thank you guys for coming on, but please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms, and remember to get engaged.